thank you, Dr. Cook, for that very stirring introduction. And yes, I think I did. I was trying to keep the bio short, so I wasn't trying to slight China Grove, but thank you for mentioning it. I was going to bring that up, that we have that connection, but I have been a part of China Grove as well as my home church for some time now, and I certainly enjoy the work that they are doing there. I would like to thank you all for allowing me to serve as the speaker for this very special day. Dr. Fahir, thank you for inviting me, Dr. Pat Lola, our Dean of Arts and Sciences, and all of you who are here. In the absence of Dr. Cook and Dr. Buckner Brown and all of the administration, I'd like to thank them as well for seeing fit to invite me to be the speaker for this occasion. I see my colleague, Dr. Begini from Mass Communications is here. Thank you for coming out to support me. And one of my students, Ms. Malloy, is here, and anyone else I see, Ms. Pam Pruitt and other people. I'm sorry if I leave anybody out. And two very special people are here, my parents, Ernest and Martha Walker, who traveled from Vicksburg to support me in today's efforts. I celebrated a birthday yesterday, which was September 17th. So my parents and I tell me that they waited and had me on Constitution Day. So I don't know if that was planned or what, but I celebrate my birthday on the same day that we celebrate the Constitution of the United States. So Mom and Dad, y'all did that. 25 years ago this week, I was in the last semester of graduate studies at the University of Memphis. As I neared the completion of the master's degree program and working on my thesis, I was faced with a new beginning as a mother to my firstborn, who we call Gigi. She was a sweet and precious baby girl, but she had needs that required me to find a job so I could contribute to the growing diaper budget. That job search opened the door to a career opportunity here at the Alcorn State University. As a Tuvaluan, I felt a little like a fish out of water, but the chair at the time, Dr. Rahman, and the dean, the legendary Dr. Norris Edney, quickly put me at ease. And although my Alcorn journey came about via occupation versus matriculation or association, I have developed immense love and respect for this institution and what it has done not only for Mississippi, but for the world, as it prepares scholars and professionals to be brave and confident in a world that does not always appreciate that type of swag and intelligence. I am so happy to be here and so thankful for this opportunity to speak about something that affects every facet of our daily lives and our presence here in the United States, the Constitution. If at first you don't succeed, try again. That is what the founding fathers of this great nation sought to do in May of 1787 when they convened in an assembly room in Philadelphia, Pennsylvania. 10 years earlier, there was an attempt to formalize American government with the Articles of Confederation. For a number of reasons that we won't get into here because of time, the Articles failed, and in search of a more perfect union, about 55 delegates, give or take, traveled from 12 to 13 states with their ideas about how this new nation should be governed. Just to illustrate how important this was and how high the stakes were, it was hot that summer. There are not any specific temperatures reported, but some reports say it was unbearably hot and humid. How many of you were here in Mississippi over this past summer? So you all know that we experienced, firsthand that we experienced the hottest summer on record. And some of these records that were broken go back to 75 years or more with the temperatures that we experienced during the heat storm. Sometime last month I had a conversation with a gentleman from Wisconsin who said it was so hot there until the students were being dismissed from school. And I chuckled as I thought about how people tease us Southerners for being overly cautious about snow and ice. You know, all it takes is one snowflake and we get the day off, right? So we may not be fully prepared for snowstorms, but we do know about heat. And we don't have very many, if any, heat-related cancellations. So maybe that means Southern people are built to last, but thankfully we are equipped with air conditioning, ceiling fans, and box fans to take the edge off when the temperatures do rise. The delegates in 1787, however, were not as blessed. Box fans and air conditioning would not be invented until decades later after the convention. Yet and still, these men properly attired in coats and vests met in a closed assembly room located in Independence Hall in Philadelphia, Pennsylvania. The delegates had taken a vow of secrecy, and although the idea was to come with the government representative of we the people, the windows and the doors to the assembly room were kept shut. The delegates needed the freedom to debate and deliberate without the unnecessary interference from members of the public. There's a saying that too many cooks spoil the broth, and this is probably why participation at the convention was so limited. There's also a quote from Nelson Mandela that says, "When the water starts boiling, it is foolish to turn off the heat." I'm sure the delegates were hot, it was sweltering, they were sweaty, body odors were probably very offensive at the time, and there was a lot of debating and argument, because of the physical and the figurative heat in the room. And so figuratively, the water was boiling in the assembly room, but the delegates stayed committed to the cause. They kept the heat turned up, and the end result was a 4-page handwritten document that established and created a system of government that has stood the test of time for nearly 236 years. It was not a perfect document, but its very structure has allowed for the expansion of rights and changes that have impacted the citizenship of marginalized groups. Changes such as the 27 amendments that have been adopted since the time that the Constitution was enacted. For example, at the signing of the Constitution, a slave was considered to be 3/5 of a free individual for determining congressional representation. This was repealed by the 14th Amendment in 1868, which for the purposes of today's talk was very integral to the expansion of access and privilege for people who have been historically, and I borrowed this phrase from talk show host Joe Madison, historically underestimated, undervalued, and marginalized. The 14th Amendment granted citizenship to all persons born or naturalized in the United States, including formerly enslaved people, and provided all citizens with equal protection under the laws of this country. It was ratified nearly 90 years after the Constitutional Convention, and as effective as the Founding Fathers were thought to be, there was not inclusiveness as far as what we think about inclusiveness in 2023. America was metaphorically described as a melting pot as early as the 1780s, yet the delegates at the Constitutional Convention did not immediately reflect what we think of as a melting pot. There were no women, there were no blacks, there were no Native Americans, there were no openly gay attendees, etc. The majority of the delegates were born in America. The immigrants came from places like Ireland, Scotland, England, and Wales. There weren't any immigrants from indigenous countries like Mexico, Ethiopia, Guatemala, and by today's standards, it is inarguable that the group lacked diversity. But as much as the delegates were similar, there were a few stark differences among them. Many of the founding fathers were slave owners, but some of them were outspoken abolitionists. Several of them had formal educations, but some, like Benjamin Franklin, were self-made dropouts. About half of them had trained as lawyers, with the rest working occupations such as merchants, shippers, bankers, physicians, ministers, and farmers. They ranged in age from mid-20s to 81 years old. It was not a perfect representation of a melting pot, but the differing viewpoints and perspectives represented in that hot, muggy room in Philadelphia led to a living and breathing and complex document that has evolved and adapted as our country has moved forward. But it has also provided a steady threshold against which all new laws are measured. The Constitution allows for self-interpretation by the Supreme Court, which handed down its first decision in 1791. Since that time, some of the court's interpretations of the Constitution amid changing times have made perfectly good sense. For example, in 1954, the court's ruling in Brown versus Board of Education determined that segregated educational facilities were unconstitutional. So we can agree with that and appreciate that right. In 1978, the court ruled in the Regents of the University of California versus Back that affirmative action programs were constitutional as a way to diversify the student body. And so this was a win as well towards ending segregation on the higher education level. But there have also been times, especially in the last couple of years, that the Supreme Court has left people scratching their heads. 2022, the court overturned Roe v. Wade, which ended nearly 50 years of women's abortion rights. In 2023, this year, not too long ago, the court issued a ruling that weakens anti-discriminatory laws that have protected members of the LGBTQ community and others from poor treatment. The court also ruled against President Biden's student debt relief program, which would reduce the debt burden for marginalized groups with limited resources, so groups who are trying to, get their piece of the American pie, but student loan debt, surmounting debt, is keeping them from being able to reach their financial goals, and the court ruled against those efforts. And then, of course, there was a court ruling this summer that may change the course of higher education for years to come. The name of the case was Students for Fair Admissions versus Harvard. The court was asked to rule on a challenge to the admissions process for Asian Americans at Harvard and the University of North Carolina. Both schools had built-in distinctions that allowed race-conscious admissions. The court measured those practices against the Equal Protection Clause and determined that the two universities were conducting their admissions policies in a way that violated the 14th Amendment. The same affirmative action tool that gave ethnic minorities a chance to further education was now being used against them and had been deemed ineffective and unconstitutional. Some supporters of the court's ruling say that having race-neutral admissions will not affect diversity at schools with predominantly white populations. However, even before the court's historic ruling, there were at least 10 states that had already banned race-conscious admissions at their universities and colleges. As a whole, some researchers say that racial diversity at those schools suffered immensely and drastically following those changes to the admissions policy, so it backfired on them. And some have said, well, if the PWIs won't accept our students at their schools, then they just need to come on over to the HBCUs. I totally agree, and I'm sure that Dr. Pat, Dr. Cook, and all of the other administrators here at Alcorn would love to have that type of influx at our HBCUs. And I try to encourage just about any student who will listen to me to strongly consider an HBCU, whether it's Alcorn or any other HBCU, because I know firsthand the value and benefits of attending these dynamic institutions. But the reality is that although HBCU should be the top choice for anyone who is seeking higher education, the Constitution demands that our children should have the right to seek and be considered for admission to any college or university they desire to attend. The fact that we are sitting here today at the oldest Black historically land-grant institution is not something to be taken lightly. The right to an education was an exclusive right for slaves. The laws in each state varied, but in general, it was illegal for slaves to learn to read and write. The little education they did receive was usually in the form of religious instruction approved by their masters. The first HBCU was founded in 1837 in Pennsylvania as a training school for people of African descent. At the time, segregation was legal, slavery was legal, but realizing the value of education, the founders pushed forward. Their determination likely set the tone for the approximate 107 HBCUs that would appear in years to come. As most of us know, the founding of these institutions is just a small step in helping students to pursue their educational dreams. And adequate funding from the same entities that finance non-HBCUs has created a level of disparity between HBCUs and PWIs. Here in Mississippi, the Ayers case was filed in 1975, with the chief complaint being that the state of Mississippi was violating the Equal Protection Act clause of the 14th Amendment by underfunding the state's three public HBCUs, Alcorn, Valley, and Jackson State. That case was settled in 2002, nearly 20 years after it was initially filed, and although the settlement ended the litigation, the Ayers family was not pleased with the outcome. And this may be a discussion for another day, but they, along with others, did not feel that the settlement properly addressed the issues brought in the initial complaint. See, Dr. Dullman, talk about photographer is doing his job.
Thank you.
Knowledge is certainly powerful. The basic skills of knowing how to read and write are what empower people from all walks of life to understand the world and make decisions based on their own perceptions. I've talked about the right to an education from the perspective of people of African descent and slaves, but women of all races have been marginalized as well. Yes, there were plenty who went against the odds to pursue formal degrees. For example, Dr. Jane McAllister, a Vicksburg native, who was the first African-American woman to earn a doctorate in education in 1929. But it was not until 1972, when Title IX was passed, that the government acknowledged that the right to higher education should not be encumbered by sex discrimination. In 1982, the Supreme Court issued a ruling that gave immigrant students the right to attend public schools. So in short, we cannot take for granted the gains that have been made in education on all levels for all people in light of the Equal Protection Clause. Nor can we take for granted all of the rights that have been hard fought and won in the past 236 years since the Constitution was signed. The right to vote, the right to contraception, the right to wear your hair how you want to, the right to marry who you want to, the right to eat, shop, live, pray wherever we want. These rights are definitely more than a notion. I am a licensed attorney who has been blessed to serve as an elected judge. I enjoy what I do as I work hard daily to uphold the rule of law and make sure that the courts are accessible to all citizens. To be effective, there's a lot of reading and writing required, two skills that have been enhanced by my experience as a journalist. Nowadays, some students come to the mass communications department wanting to focus only on the technical side of the field with the recording and editing equipment, but there is also in our curriculum a strong emphasis on developing their writing and critical thinking skills as well. And the First Amendment is at the cornerstone of a lot of the objectives that our students have to master. At the time that the First Amendment was drafted in 1791, freedom of the press referred mainly to the printing press used to create handbills and pamphlets. It was a slow and laborious process just to get the words on paper, and beyond that, distribution was limited because of bad roads and a slow postal service. In 1791, there was no telegraph, there were no telephones, no radio, no television, no internet, no social media, yet the First Amendment has been or will be interpreted in hundreds of cases concerning these newer forms of media. Considering the string of questionable rulings in the past year, there are concerns, understandably, about whether the current Supreme Court will at some point limit the power and the access to the internet. So far, there has not been a definitive ruling on any of the internet-based cases that have been presented to the court, but that day is certainly coming. The Constitution established the three branches of government: executive, legislative, and judicial. The checks and balances system is designed to keep one branch from becoming more powerful than the other two. It works in some instances, but sometimes, depending on the personalities and other factors, it doesn't work. And some say the media acts as an unofficial fourth branch of government because of its function as a watchdog of the government. Historically, the media's job has been to provide citizens with information they can use to check government power. Nowadays, with so many citizens having access to social media and government documents via the internet, additional roles have emerged as citizens seek to hold government officials accountable and the media accountable. Some call this group of bloggers and commentators the fifth estate, or an unofficial fifth branch of government that demands further accountability from the powers that be. I often ask my students about their news consumption habits. Almost none read a daily newspaper or watch the evening news, television news. I'm sure that does not come as a surprise that this current generation does not do that. Very few of them subscribe to or follow news anchors like Google News. Only a handful of them are listening to news on the radio. And so where are their views of the world coming from? Largely from word of mouth or from what they see on social media. And I am the parent of two 18-year-olds, one of whom is an avid TikTok follower. She gets all of her ideas about fashion, recipes, news, health, everything from TikTok. And so that's what she does. She's not going to sit and watch the news with me, nor is she going to read a newspaper. And so there's a wealth of information out there on the internet and social media. Some of it is factual, some of it is not. And so what concerns me, and there's nothing wrong with social media, it gets a bad rap sometimes, but there is some value in it. But a concern is because of the algorithms that cater to our social media users' personal preferences, young adults and old ones as well are not getting a healthy dose of current events. If the platforms pick up on the fact that you like sports, then what we see in your news feed, sports. If you like music, then you'll see music. And so when it comes to politics, national news, or world news, financial news, for most of us, unless that is something that we avidly seek out and follow, these updates will be filtered out if they don't directly match what we appear to be interested in. And that can be very dangerous. Nelson Mandela said, an educated, enlightened, and informed population is one of the surest ways of promoting the health of a democracy. And it's not just the younger folks, as I mentioned. Some of us more seasoned consumers could benefit from having a more balanced news diet as well. The more we know, the more we stay informed, the more we can make intelligent decisions about business, about politics, about health, and about finances as we continue to preserve access to the rights guaranteed by our system of government. To do anything less is reckless, especially in light of the hard-fought wins that have occurred throughout history. The right to vote, the right to fair trials, the right to privacy within your home or your vehicle, the right to an education, the right to work. A little knowledge goes a long way when you're engaged in a healthy debate, whether you are on social media or you're on aisle 2 in Walmart. And you don't necessarily have to agree with the person you're debating with. The Supreme Court has said that these friendly types of discussions are what lead to the discovery and spread of political truths. And I'd like to put an emphasis on the word truth. 2 Timothy 2:15 says we should study to show ourselves approved unto God. And I know that we have separation of church and state, but our very Pledge of Allegiance describes the United States of America as what? One nation under God. God also appears in the Declaration of Independence, and he is on our cash, both dollars and cents. God. And God we trust. God is love and God is truth. So we adapt 2 Timothy 2:15. We should study to show ourselves approved unto the truth. And so many of the trailblazers from the abolitionist era, the Jim Crow era, the civil rights era, all of these different movements that have occurred in our country, if you look at their stories, a lot of them appear to be divinely inspired. So I would venture to say that it makes perfect sense to stay informed and vigilant when it comes to matters that could affect our constitutional rights. They've been very hard fought, but as we see, like in the span of 2 years, a lot of these rights have easily been diminished. And so with these rights come great responsibility, and we all should be equipped for the challenge. So I'd like to thank you all once again for having me as your Constitutional Day speaker. I hope I said something that enlightened you and hadn't got you to thinking. So thank you all once again, and you all have a great rest of the day.